It has been a particular honor for me to serve on the Court of Appeals for these past 15 years because it has given me the opportunity to use whatever talent I have to serve my country by upholding the rule of law. And there is nothing that is more important for our republic than the rule of law. No person in this country, no matter how high or powerful, is above the law, and no person in this country is beneath the law.
Hey, everybody. Welcome into a special episode of the Can We Please Talk podcast. As always, I'm Mike Leon.
And I'm Nick Saveri.
On the program today, Nick, just when I thought I was out, the Supreme Court pulls me back in. Just as they're about to head into recess, they drop a bombshell on us. They say presidents are immune. Who knows from what? We're going to find out from what, because joining us today on this special episode, she's a former federal prosecutor. I met her over at CNN as we were doing some hits earlier last week. Alyse Adamson joins us on the pod. Alyse, thank you so much for hopping on with us.
No problem, Mike. My pleasure. Although not really a pleasure to read SCOTUS's decision, but my pleasure to join you this evening.
Well, we truly appreciate you hopping on the program and giving us a couple minutes. Normally Nick and I would exchange some pleasantries here. We do some ad reads and promote some more content, but we're not going to do that right now because I want to get into this right away because, this everybody was expecting this to come down at 10 o'clock. All the legal beagles everywhere were saying there's going to be some type of ruling that's kind of in the middle, right? They're going to say a president does have some immunity, but not broad immunity, right? You can't kill your political rival. But I just want a 30,000-foot overview for you. When the ruling came down, can you explain to our audience what the ruling actually entails and where does it go from here?
Yeah, sure. Well, I guess to just comment on what you said, you can kill your political rival according to this ruling. So yeah, look, we knew they were going to end up sending this case back to the lower courts for Judge Chutkan. That is the judge who's going to be overseeing Donald Trump's Jan 6 case to make some evidentiary findings on what is official acts and what is private acts. But what we as legal analysts did not expect was the Supreme Court to give a president such broad immunity. And so now here's the 30,000-foot view, okay? What the Supreme Court said today is there's basically two different kinds of conduct for a president. There's official acts, and then there's unofficial acts. Unofficial acts, that's considered private conduct. It's something you do completely outside of the presidency, not related to your job at all. You can be prosecuted for that. That wasn't a surprise. We all expected that, right? Like, you're not acting as a president, not even touching the office. That's fair, okay? Then there are these official acts. And this is what all of us in the legal world knew that the Supreme Court was going to probably find some limited immunity, right? Like, there are some things the president can do that might be shielded from criminal liability. Supreme Court blew those expectations up. And now they say there's two kinds of official acts newly recognized with this magic ruling today. There's absolute immunity for official acts that are derived from a president's constitutional power. So things that the Constitution gives the president power to do. So that's commander-in-chief of the military. That's going to be like the power to pardon. The Constitution lays out that the president has authority within these areas. Supreme Court says they've got absolute immunity there. So courts can't touch it. And that's where you heard in Sotomayor's dissent, she's talking about SEAL Team 6, order SEAL Team 6 to kill a rival, immune. And that's because as commander-in-chief of the military, he has what they call conclusive and preclusive authority there. And the court can't touch it now, immune from prosecution. Then there's this other official acts. This is like everything else. They call this presumptive immunity. So the Supreme Court saying probably has immunity, but here we're going to give the government an opportunity to argue that maybe they shouldn't be immune. But the test for that is so broad, and I wrote it down because I don't want to get it wrong. For a court to find that the president does not enjoy any immunity for everything else, the government has to show that there's no intrusion on the authority and functions of the executive branch. That is so broad, you can drive a truck through it. I don't even know what it means. I don't think most legal analysts know what it means. And just to give you an example, in the opinion, Chief Justice Roberts can't decide, he can't determine whether or not Donald Trump's decision to try and influence Mike Pence to take those false fake electors during the certification process, he couldn't say one way or another whether that would be an official act that has presumptive immunity or not. He said, well, on the one hand, probably can't call your vice president and tell him to do this thing, but like communicating with the vice president is also part of the presidency, and that would probably be an intrusion on the executive branch if we prosecuted people for those conversations. So it doesn't make sense. They remanded it. That those questions are going to have to be solved by the trial court, by Judge Chutkin in a hearing. But guess what? If Donald Trump's team doesn't like how she has resolved those issues, it's going right back to the Supreme Court. And what we have read and everything we heard in oral argument, I am not confident that it would go any way but Trump's. So that's a lot of talking, but that's the 30,000-foot view. And the headline is presidents now enjoy broad immunity, basically kings.
Alyse, correct me if I'm wrong, but historically, isn't the court's role to essentially be the safeguard for the Constitution, to basically be the arbiter of if something is coming forward, be it a decision by president, act of Congress, that essentially we look to the Constitution. What you just described sounds like, especially if this decision from the lower court comes back up, that the Supreme Court has now suddenly taken on the role of being its sole arbiter, where they want to, whether intentionally or not, make all these critical decisions. In your view, has the role of the court shifted just by the actions or mindsets of this particular round of 9 judges?
Yeah, I would say so. Justice Sotomayor actually referred to them as an activist court in a footnote in her dissent today, and I think that is a good way to describe them. You're absolutely right, Nick. The Supreme Court is supposed to be interpreting the Constitution, and that is ostensibly what they're doing. They're claiming they're interpreting the Constitution, and they're using a lot of historical framework. You will see in this opinion, they're using the Federalist Papers. But how they're doing it is they are, in my opinion, using their own judgment of today, and they are supplanting that of the framers, but then saying it is the intent of the framers. I called it mental gymnastics earlier in a post of mine, and that's what it appears to be. And so, yeah, I think that they have gone further than the role of the court was anticipated by the framers, which is funny since they always talk about giving so much deference to the framers and their original intent. But I agree with Justice Sotomayor that what we are seeing is indeed an activist court.
Alyse, let me go back a second for something you just said, because what I don't want to get lost in, and you broke it down really well, but as I was listening to you break it down, you said something about now it's going back to the lower courts and the judge that's overruling the DC case that we should mention. There was 4 cases, obviously, in Florida with the Mar-a-Lago stuff. There's the one in Georgia with Fannie Willis leading the prosecution there. There's a New York one that wrapped up. And then obviously there's one in DC with the obstruction of an official proceeding. So this is going back to the lower courts. So now what happens here procedurally? Because you touched on it a little bit, but it sounds like they're going to go in and like mark what's an official act, as you're rolling your eyes for people watching us on YouTube as I'm reading this out. So she has to go in and mark what's an official act and what's not an official act. But then what you just said was that Trump's team could say, no, that's an official act, and they can continue to contest it and this dance. Won't that affect like every single case, every single president going forward? Joe Biden right now decides that he wants to lock Donald Trump up. Like, wouldn't that cause chaos? Am I oversimplifying it? Or is your head nodding in agreement saying that, no, Mike, you're absolutely right. This is going to cause chaos upon chaos because this could spend so much time in the courts.
Yeah, I was rolling my eyes because while you were talking, I was just imagining what this is going to look like. I spent a lot of time in court litigating various things. And so what you're describing, it is like, it is a litigation nightmare. So what's going to happen is the case is going to go back to the trial judge. The trial judge is going to have hearings, evidentiary hearings, so she can determine what was an official act, what was an unofficial act. That's going to be essentially a mini trial. She's going to take testimony. She's going to have to parse out through the indictment what was an official act, what was an unofficial act. Then the defendant, that would be former President Trump, can take what's known as an interlocutory appeal. That's an appeal that happens before a case is resolved, before it goes to the jury and he's convicted. Usually that's when a defendant appeals after they've been convicted. This was considered a pretrial interlocutory appeal that went up to the Supreme Court. Those are rare, but those are going to be allowed here because these are questions about whether or not a case should even be proceeding to trial. So you're absolutely right, Mike, that this is not just going to affect this January 6th case, but it could potentially affect the Georgia case. Now, limited effect in something like the New York case, that's already been resolved, and most of the evidence there was for things that happened before he was elected president. This only pertains to acts that were taken when he was in office. Same with the Mar-a-Lago case. A lot of that stuff happened after he was out of office, so this won't affect it. But you're right, for the future, any president that is subject to criminal prosecution, or could be, which maybe more will, since they feel like they have a get out of jail free card, if it goes to this litigation, that's what it'll be. Hearing after hearing, contested after contested. And you know what? The Supreme Court anticipates they're going to have to hear more appeals to make these tests and these rules clearer, because right now they're about as clear as mud.
Yeah, with that in mind, regardless of who wins, the election this fall for the presidency, do we run a risk of, because of this potential ongoing, what may feel like an infinite back and forth between the Supreme Court and the lower court in terms of deciding what is official versus unofficial, what may be a president facing in terms of making all these decisions and having to decide whether they're allowed within their purview or not? What may that do potentially to the role of the presidency?
Well, what you just articulated is what the Supreme Court says they were worried about. That's why they gave the president such broad immunity. Their concern was, if it wasn't clear and presidents didn't enjoy broad immunity, that's how they would be thinking all the time. Is what I'm doing okay? Could I be subject to prosecution? They said they feared a chilling effect on the presidency if they didn't enjoy this immunity. And so now, I mean, what we're talking about is the rare case where a president is ultimately charged and kind of determining what's a private act and what's an official act. Because I hear your point, which is, well, won't a president be concerned about what's private and what's official? But I think with this ruling, a president need not be concerned, because most of everything they're going to do will fall under an official act. And it would take something like an insurrection, say, where the conduct, in my mind, is so clearly private. Like, I don't know how we can be saying that this was within the scope of their duties. And that line should be pretty clear to any president, if that makes sense.
Alyse, I wanted to ask you, because it's funny, and I'm going to bring our convo that you and I had in the CNN Green Room this past weekend about politics and the law kind of intersecting, right? Like the law is the law, right? Even though it should be black and white, right? The scales, the blindfold on the scales of justice, but there is seldom gray. And then in the world of politics, it shouldn't blend into law. The reason I'm asking that is because, and Nick brought this up about the Supreme Court and how people are supposed to interpret this. This was before them in December. The oral arguments happened in April. They make a ruling in July, so that way no trial can happen. And I was reading earlier today in the USA Today about contrast what the Supreme Court has done timeline-wise with the Nixon administration blocking the New York Times. That was 4 days after hearing oral arguments in 1971. Richard Nixon and the turning over the secret tapes to the White House was only 16 days after hearing oral arguments. George W. Bush in the 2000 election, that all happened in December. So the timeline was within 8 weeks. So how is somebody that's listening to this right now that says, no, law is the law, politics doesn't blend in, how are we supposed to interpret timelines like this that are helping the defendant in this case, regardless of how you feel about Donald Trump. There's a trial before the American people that we should find out more information about. We didn't get that because of this being delayed so long. And there's no precedent from the Supreme Court prior of doing this. And I just gave it's 6 months. Oral arguments were in April. It's July 1st. What says you, the former federal prosecutor who's been in court all the time, who has seen delays? Am I just making this up, Mike? You're kind of way off here, or like, no, I guess a person could glean from that it does look political in terms of the timeline, and it's not really being expedited.
Well, first, to be fair, there are cases where there's a delay, where oral argument will be heard and then they wait to the end of the term to issue an opinion. So this isn't just a complete outlier. And actually, I think the Supreme Court anticipated that critique, because within the opinion, there are some snipes at both the prosecution and the lower courts. What they say is they feel like the lower courts were rushing and that they expedited, to use your own word. They actually use that in the opinion. They feel like the lower court and the DC Circuit, which is the appellate court right below the Supreme Court, expedited their decision. They said they went too fast. The Supreme Court's arguing in their opinion, and I think to answer this point, by saying this is a case of national importance. We really needed the time to think through this and weigh it, and that's their argument. But you make a good point, which there have been other cases of national importance, which they have decided much more quickly. And if they had put all their effort and their time into rendering opinion, they could have done it on a different time frame. I think the case that best exemplifies undue delay is actually the Mar-a-Lago case. So the Supreme Court taking months to issue an opinion, right, wrong, we see that. I think that's less political. The case we're seeing out of Florida, that has been delayed indefinitely. You have hearing upon hearing. The judge is granting these testimonial evidentiary hearings for every single motion. It makes no sense. I think that one is a stronger argument for potential politics being in play, because there's no reason for it. And I think most people who practice in a courthouse will tell you they've never seen anything like that. But the other point I want to make is the Supreme Court's kind of opening itself up to this critique about bias in politics, because, and we talked about this in the green room, you have justices like Clarence Thomas who are accepting luxury vacations from Republican mega donors. So even if, I just gave a reason for why it might be reasonable for this opinion to have taken a few months, but we're asking the questions because the optics are bad, right? Like, how can you say there's not a little bit of bias when this guy is hanging out with a mega donor? It does not look good. And when you're the Supreme Court, you should be minding your P's and Q's. Like, you don't want an appearance of impropriety. So I hear you on your critique, and I think they opened themselves up for such critique by their behavior.
At least this has come up a little bit because you just mentioned Justice Thomas, and obviously what we saw with, some of the interesting possessions we can say of Harlan Crow, and potentially a Supreme Court justice, maybe one of them, I guess. But we also have seen, obviously, the story with Sam Alito and, that early decision in matters of Roe, that early, copy of that text. It feels like we've seen in the past year and change examples individually of justices that are blatantly political, like there's an influence in where they are. But what comes up often, and you just spoke to this, which is why I'm asking this, is this perception that if we look at the court differently and we realize that they're losing our faith in what their initial intended role is, which is what we were talking about at the start of this interview, what is the potential cost of that? Because at this point, and again, I'm not an attorney, obviously, but if we are outright aware, and we know everything from Ginny Thomas to, obviously Justice Thomas, that he probably is unfit to serve in some of these cases, but there doesn't seem to be any legal recourse to remove him from the bench, nor Justice Gorsuch, which we saw recently in the Chevron case, who obviously was tied to his mother, from what I remember in terms of precedent. Is there any legal recourse that can happen if a member of the court is essentially, for lack of a better phrase, out of pocket?
Yeah, not really. I think there is some congressional mechanism, and I don't want to misspeak. I know for federal judges on the lower benches, it would have to go through Congress, but that's why I'm like, it's just not going to happen, right? especially here where these are ethics violations and the Supreme Court is self-policing. They issued a new policy after the revelations of Justice Thomas and Harlan Crow, but I mean, that's all it is. It's just a policy, and they're supposed to adhere to it, and there's no enforcement mechanism. It's toothless. So I think, to answer your question, like, what is the consequence? It's our democracy, because you do have people serving on the bench for life, basically unremovable, and people are losing faith. And I think, and this is just my opinion, I think January 6th was the beginning of it, because all of a sudden the unthinkable happened. We watched an assault on our Capitol. We saw members of Congress almost maimed. I mean, if folks had gotten in there a little bit sooner, who knows what would have happened, right? And I think that was the first time a lot of people said, wow, I think our democracy might be fallible. These people tried to overthrow the government by subverting the peaceful transfer of power. Now we have a Supreme Court that has just essentially given the president just really, really broad sweeping powers that the Constitution could not have really intended for the presidency to have. And on top of that, this same court has justices that are engaging in very overtly political behavior. I'm thinking of Alito with the flag in his front yard, to no recourse whatsoever, to your point, Nick. And so it is harming our democracy. The rule of law seems to be under attack, and that is one of the cornerstones of this country. And I am concerned we are not going to be able to operate the way that we have been for over 200 years if the people lose faith in our institutions. If the president is allowed to do whatever they want to do unchecked, if the Supreme Court is allowed to engage in political activities and go unchecked, what does that say? And Congress can't get it together. They're fighting constantly. We're at a point where it's more polarized than it's ever been. How are the American people going to view their system of government, and how are we going to be able to proceed the way the framers intended? I don't want to be a pessimist, but I am not liking what I'm seeing. And I think that a fundamental shift in our government is what the consequence is going to be. And that is just going to be devastating.
Well, no worries on the pessimism here, because you've come to the right show. So, Alyse, let me ask you this as before we let you go here, because you've been so gracious with your time. I did want to ask you, because I've heard, as I was watching the coverage today of some of the other legal beagles that are friends of the show, making the rounds, and they were talking about the other cases that are involving the former president, and how now this decision could impact some of that, right? Where you could say in New York, in the New York case, and the ruling that just came down, the sentencing hearing is coming up next week. But you could say, well, the president was having conversations with Hope Hicks, and that was during the White House, and that was part of an official act. Or you could have something in Georgia with respect to the president. Again, it's a little bit different. I get the scope. I get the thought process behind it, where it's like, well, the person is the incumbent, but they're running for office. So they're doing things in the campaign, but also the president of the United States. So like, I get that. But what now about these other cases? Now that this ruling has come down, is there any through line specifically that kind of ties in with this ruling and some of these other cases across the different jurisdictions?
Yeah, the New York case, less worried about it. The Hope Hicks testimony didn't carry the day. And I think the most relevant testimony from Hope Hicks occurred in 2016 before the election. It was about what the president was afraid the impact of the Stormy Daniels story would be, or maybe it was the other story, but one of the damaging stories. And so that was before he was in office. So this ruling won't impact that at all, because this only it affects acts that happened once he was president. And so I don't think that this ruling would materially affect the outcome of that case, even if they were to toss any testimony of conversations that happened after Donald Trump was the president. Even then, those would be private acts, because he was trying to suppress a sex tape or a sex story. And so I don't think there's any kind of argument that was an official act. I think, and with Mar-a-Lago, most of that happened after the presidency. I am curious about Georgia. I am curious about Georgia because the facts are very similar to those in the Jan 6 prosecution. It's all about the fake electors trying to subvert the election. That's the harder case. And Georgia has already been upended by the Fani Willis debacle, which, right, wrong, or indifferent, kicked the can farther down, because now the appellate court isn't even hearing that until the fall. And so they're going to be able to delay this forever. And remember, this is what's important, and your viewers and listeners should key in on. The Georgia case is one that Donald Trump cannot dismiss if he became president. You'll hear a lot of you say legal beagles talking about, well, now none of these cases will ever go to trial. He gets reelected, he can just get rid of them, right? He can't get rid of a state case. Can't get rid of a state case. And so his team will probably litigate tooth and nail with this ruling, because that case won't go away even if he's president.
Alyse Adamson, you can find her across news outlets. You can find her on CNN, like how I found her. And she's also a former federal prosecutor. Alyse, I can't thank you enough for hopping on the program. Continued success to you, and please stay safe.
Thanks so much, Mike. Thanks for having me and letting me share my thoughts. Really appreciate it. Nick, appreciate it.
Quick break from our pod to tell you about a new pod at Fresh Roasted Coffee, Envy Pods. So if you go to freshroastedcoffee.com, my partner's shaking his head. That's a good transition. Are you kidding me?
It was good. No, I shook my head. I was like, that's brilliant.
Thank you. Thank you.
Because I saw this picture earlier. I was like, I saw what you're doing.
That's right. It is a fantastic transition, Nick, if I do say so myself. Listen, the new Envy Pods over at our partners at Fresh Roasted Coffee. These pods are environmentally safe. They are compostable. And let me tell you something. When you open these individually wrapped pods, Nick, they smell absolutely delicious. You can check out these new pods from our sponsors over at freshroastedcoffee.com and enter in the new promo code. Can we please get 20, all one word, and the number 20. Can we please get 20 for 20% off your purchase? Head to freshroastedcoffee.com today. All right, that was Alyse Adamson, like I mentioned, former federal prosecutor. Fantastic work. She's always over there on CNN, some other outlets as well. I happened to run into her, funny enough, last week in the green room, and we were talking about doing some stuff, her coming on the program to help us explain some things. And I didn't even realize that the Supreme Court was weighing in on this decision yesterday. And so it's pretty funny that, well, not funny that it happened, but per chance meeting her in person for the first time. So shout out to her. She does fantastic work. Like I said, good explainer there. Nick, you were mentioning this as we were rapping with her off air about the president's comments, and what he said about the ruling. I want to take a listen to this and we'll react on the other side. So take a listen.
This nation was founded on the principle that there are no kings in America. Each of us is equal before the law. No one is above the law, not even the President of the United States. With today's Supreme Court decision on presidential immunity, that fundamentally changed. For all practical purposes, today's decision almost certainly means that there are virtually no limits on what a president can do. This is a fundamentally new principle, and it's a dangerous precedent.
So, Nick, you heard the president there. Dangerous precedent this sets. I think we're all in agreement that it's an incredibly dangerous precedent because, yeah, sure, like you and I have been texting back and forth. Yeah, sure, a president should have immunity from certain things. So, for example, your country gets attacked. You decide to go out there and attack back the country that attacked you, right? For military purposes, protection, you're in charge of the military. You have to protect your people. That's what a government's supposed to do, protect its people. And so you end up killing people in that process. You can't get charged with that crime because that's part of, being, the office of the presidency. Like that comes with the territory, right? But this sets a really bad precedent because now it's almost like, and you asked this to Alyse, it's like a very nitpicking thing. So while I'm in the office, what can I actually do? Does it hinder the job? Does it give me broad scope? Apparently it does. Now I can just do whatever I want, carte blanche, which could set up for somebody even more dangerous than the two candidates that we have potentially, like utilizing this in like whatever direction they want. I mean, we all think President Biden won't do anything, but now he can apparently, and nobody should say anything, right? Am I wrong? What says Nick Severi?
Yeah, well, prior to President Trump, I've been thinking today of, if this precedent had been established before, what presidents would we be worried about that would possibly try to skate on this? And there's not many that stand out. Maybe Nixon possibly could use the argument that this was an official thing and the Watergate was under my official capacity, which is a little ridiculous. I mean, you had a theft in an office building by your people. That's hard to justify. Similar to a former president saying, I need 11,000 votes. There are some things that logically seem hard to defend in an official way. But the problem with the court, and this is something similar we saw with the interpretation of that one bylaw, whatever, the 14th Amendment, right? This idea that we can't quite say whether the president caused the insurrection because according to the amendment, did he directly do it? But he's the president. The president wasn't named as a federal office. And there's a lot of hand wringing when common sense would be really, really helpful right now. I could ask the average American, do you think, now again, obviously right now we're the place where people are just so politically in their camp that maybe people can't think straight here, but I'd like to think the average American, if you presented them with the idea that the president of the United States could be immune from any form of prosecution or punishment because are you okay with that? I'd like to think the average American would say probably not. Like that seems a bit of an overstep. So the court, though, doesn't seem like the average American person. 9 people, 6 of them specifically, had this weird legal interpretation of, no, it seems like official capacity. Now, full disclosure, you and I were texting about this earlier, and the example I bring up, you mentioned about war powers. The most extreme example I can think of is President Truman, the bombing of Hiroshima and Nagasaki. Would this be something that if he was legally obligated to potentially be held in trouble for, I'm being overly simplistic here, does he still make that decision? Like, what as a country should we do in response to that? Whether you agree with it or not, we're not having that discussion here. But that's where the vote comes in. And I think that in some ways is what the court's basically telling us all, is that, if you want to put someone in who's not going to abuse these powers, who understands what an official capacity is, then don't vote for the real estate reality TV guy. Like, vote for a sensible human being. The problem is at least 40%, and probably after Thursday's debate, it's getting closer to 48%, feel that the carnival barker real estate dude is the guy they want. And we all know, I think the one reason that there's so much doom and gloom on social media and all that place is that in most cases, we don't think of any particular president that would use this interpretation to vastly overstep what they're doing. Like, do I think of someone like Abraham Lincoln thinking about this and saying, well, with this in mind, not only do I have to go after the Confederacy, I could go after anyone. No, we don't think Abraham Lincoln would do that. The person who very likely or has a very good chance of winning and going back into the White House is a person who has threatened to jail his political opponents, as a person who has thrown out the idea of being able to murder someone and have enough support that he wouldn't be prosecuted, right? That's where the fear comes from, is now for the first time, we are really looking at someone that we think, wow, yeah, unchecked, that person absolutely could pursue the most heinous of activities under an official capacity.
Yeah, I think the biggest analogy I will draw for people as we wrap here is you think about not so much January 6th, but you think about the actions of people post that, and then the interviews with people post that there's been some people that if they didn't stand up and say, no, this is not the way it is, I'm going to uphold the rule of law. I think of my buddy Jeff Duncan, who was a former lieutenant governor in Georgia, super Republican, voted for Trump, was like, dude, the votes are not here. Like, I'm telling you, they're not here. I'm overseeing this election with the Secretary of State, and it's not here. And if not for, that last line of defense, this whole thing could topple. And I think people don't know what is on the other side of that toppling. But I will say one thing I would point to, and it's not the same because, again, it's really, it was more financial, but Brits leaving, the European Union and, going on their own, and they put it up to a vote, and like 53%, I think, of people won in that vote to leave the European Union. And they felt it from an economic standpoint over the first like 18 to 24 months since leaving. And there was a lot of regret from people. And it was like, well, I mean, if you didn't vote, you can't complain then. If you don't participate in this process, you can't complain. And I think that's the biggest thing that I learned from all of this. We leave it there. Our thank yous again to Alyse Adamson for coming on the program. If you want to check out the video portions of our interviews with Alyse or any of the other legal beagles that we've had on the program, as she put it so politely, head over to our YouTube channel, type in Can We Please Talk Podcast. We should pop right up. Hit subscribe while you're there. Audio podcast platforms you know by now, Apple, Spotify, Google. Shout out to everybody who listens to us over on Good Pods. Shout out to Acast, our hosting platform. We can't do it without them. Can't do it without each and every one of you that listens to this program. We'll be back in a few weeks with all new episodes. As always, I'm Mike Leon.
I'm confident that even in an official capacity, I would not try to maim my political opponents. Mostly. I'm Nick Saveri.
Well, you check that out for the comments section, everybody. Nick won't maim you. We'll see everybody next time.